It was March in Iron Vale County. Snow fell outside as 18-year-old Mervyn Huerta swaggered into the courtroom, chains clinking like trophies. For him, this was not justice. It was showtime. He had told his story a dozen times. Stupid fight. Bad luck. He called it manslaughter. The jury called it possible. Through tears he did not mean, and charm he weaponized, Mervyn acted the part of a remorseful teen. But the act died fast. He smirked through the victim impact statement, chuckled as the mother's voice broke describing her son's last birthday. When the judge rebuked him, he leaned back, smiled wider. Then the prosecutor pulled the final thread, a jail video recorded just days before, showing him performing the killing for laughs. In that moment, the courtroom changed temperature. The judge's face hardened. And when the sentence came, it was not the one anyone expected. 50 hard years were added on the spot. Cameras captured the stillness afterward, the exact second an arrogant boy realized he truly was out of time. The Iron Vale County Courthouse stood at the center of the small Colorado mountain town, a stone building from the 1920s with tall windows and wooden floors that creaked under the weight of each footstep. Outside, snow continued to fall in thick, silent sheets. Inside, the main courtroom was packed with spectators, reporters, and family members who had waited months for this trial to begin. The case had gripped the community with a sickening fascination. An 18-year-old accused of murdering a former friend in what prosecutors called a calculated act of violence disguised as a street fight. Mervyn Huerta entered the courtroom, flanked by bailiffs, his orange jumpsuit vivid against the dark wood paneling. The white undershirt beneath showed at the collar. He moved with a swagger that seemed absurdly out of place given the circumstances, his chains rattling with each step. As he approached the defense table, he caught sight of the cameras positioned at the back of the gallery and flashed a wide grin directly at the lenses. One photographer caught the moment, the flash briefly illuminating Mervyn's face, freezing that arrogant smile for the front page of tomorrow's newspaper. His attorney, a public defender named Robert Carver, in his early 40s with thinning brown hair and the weary expression of someone who had defended too many guilty clients, sat waiting at the defense table. Carver stood as Mervyn approached, placing a hand on his client's shoulder in a gesture meant to convey solidarity. Mervyn shrugged it off and dropped into his chair, slouching back as if he were settling in to watch a movie rather than face trial for murder. Judge Patricia Warner entered through the side door, her black robes flowing as she climbed to the bench. Warner was a woman in her late 50s, with sharp features and steel-grey hair pulled back in a tight bun. She had presided over Iron Vale County District Court for 14 years and had developed a reputation for fairness tempered with zero tolerance for courtroom theatrics. As she took her seat and surveyed the room, her gaze lingered on Mervyn. She had read the case files, had reviewed the evidence, and had formed an early impression that this defendant was going to test her patience. The clerk called the court to order. All rise. The Honorable Judge Patricia Warner presiding. Mervyn stood slowly, theatrically, as if granting the court a favor. Several people in the gallery shifted uncomfortably. The victim's family, sitting in the front row, stared at Mervyn with expressions of profound grief and barely controlled rage. The clerk read the charges. Mervyn Huerta, You are charged with second-degree murder in the death of Anthony Reyes. How do you plead? Mervyn leaned toward the microphone, a slight smirk playing at the corners of his mouth. Not guilty, Your Honor. He paused, then added in a tone that dripped with false contrition. It was an accident. A fight that went too far. I never meant for Anthony to die. Judge Warner's expression did not change, but her eyes narrowed slightly. The plea is entered. She set a trial date and addressed the attorneys regarding preliminary motions and evidence submission. At the prosecution table sat Lise Brennan, the Deputy District Attorney for Iron Vale County. Brennan was a woman in her mid-30s with dark red hair pulled back in a professional bun and the focused intensity of someone who took her work personally. She had prosecuted violent crimes for 8 years, but this case was different. This defendant was different. Mervyn Huerta was not just arrogant, he was sadistic. He enjoyed the attention, enjoyed the drama, and seemed to view the trial as an opportunity to perform rather than an accounting for what he had done. Brennan leaned toward her co-counsel, a younger attorney named Marcus Webb, and whispered, "He thinks this is a joke." Webb nodded grimly. Let's show him it's not. The investigation had begun on a cold night in early December, when police had been called to an alley behind a bar in downtown Iron Vale. A man had been found stabbed, bleeding out on the pavement. By the time paramedics arrived, Anthony Reyes was dead. He was 20 years old, a community college student who worked part-time at his family's restaurant. He had no criminal record, no history of violence. By all accounts, he was a gentle person who had been in the wrong place at the wrong time. The initial investigation had focused on the area around the bar. Security footage from nearby businesses showed Anthony leaving the bar around 11:30 at night. He had been alone, walking toward his car parked in a lot 2 blocks away. The footage also showed another figure following him at a distance. The quality of the video was poor, the lighting inadequate, but detectives were able to enhance the images enough to identify the second person. It was Mervyn Huerta. Detective Omar Sharif had been assigned as lead investigator. Sharif was a veteran cop in his late 40s with a methodical approach and an instinct for reading people. He had interviewed witnesses from the bar, piecing together the events of that night. Several people remembered seeing Mervyn and Anthony together earlier in the evening. They had been friends once, back in high school, but their relationship had soured. Witnesses described an argument, raised voices, Anthony trying to walk away, Mervyn following him. One witness, a bartender named Carla Diaz, had particularly damning testimony. She had overheard Mervyn at the bar earlier that evening, talking to another patron. He had been drinking, his voice loud and aggressive. Carla heard him say, "He's done embarrassing me tonight. I'm going to shut him up for good." Sharif had obtained a warrant for Mervyn's arrest within 48 hours. When officers arrived at Mervyn's apartment, they found him asleep on the couch, dried blood on his hands and clothing. A search of the apartment uncovered the murder weapon, a folding knife with a 4-inch blade hidden in a drawer in the kitchen. Forensic analysis would later confirm that the blood on the knife belonged to Anthony Reyes. During the initial interrogation, Mervyn had been calm, almost relaxed. He admitted to being at the bar that night, admitted to arguing with Anthony, admitted to following him into the alley, but he claimed it was self-defense. Anthony had attacked him, Mervyn said. Anthony had been drunk and aggressive. Mervyn had pulled the knife to scare him, and in the struggle that followed, Anthony had been stabbed. It was an accident, Mervyn insisted, a tragedy, but not murder. But the forensic evidence told a different story. The medical examiner's report showed that Anthony had been stabbed 7 times, wounds to the chest, abdomen, and back. The pattern of injuries suggested a sustained attack, not a single defensive strike. There were no defensive wounds on Anthony's hands, no evidence that he had fought back. And the paramedics who had arrived on scene reported something that had stuck with Sharif. Mervyn had been standing over Anthony's body when they arrived, and according to the lead paramedic, Mervyn had been laughing. The trial began on a Monday morning in late March. The courtroom was filled beyond capacity, with overflow crowds watching on monitors in adjacent rooms. The case had attracted significant media attention. An 18-year-old accused of a brutal murder, claiming self-defense despite overwhelming evidence to the contrary. Reporters had dubbed Mervyn the smirking defendant after photographs from his arraignment had shown him grinning at cameras. Mervyn entered the courtroom with the same swagger he had displayed at every previous hearing. He took his seat beside Robert Carver and immediately began surveying the gallery, making eye contact with reporters, smiling at cameras. When Judge Warner entered and called the court to order, Mervyn stood slowly, still smirking. The jury was brought in. 12 citizens of Ironvale County, selected after 2 days of voir dire. Brennan had fought hard to seat jurors who could look past Mervyn's youth and focus on evidence. She had succeeded in assembling a group that seemed capable of doing exactly that. Though she noticed several jurors already looking at Mervyn with visible discomfort. Brennan stood to deliver her opening statement. She approached the jury box, her posture straight, her voice clear and steady. Ladies and gentlemen, this case is about a young man who believed he could get away with murder by calling it an accident. Mervyn Huerta did not kill Anthony Reyes in self-defense. He did not kill him in a moment of fear or confusion. He killed him in a calculated act of violence, an attack motivated by ego and rage. And then he lied about it. He has been lying about it ever since. But the evidence will show you the truth. The truth that Mervyn Huerta is a killer who has turned this trial into a performance and who has shown absolutely no remorse for taking a life. Brennan outlined the evidence the state would present, the witness testimony from the bar, the security footage showing Mervyn following Anthony, the medical examiner's report detailing the viciousness of the attack, the statements from paramedics, and finally, video evidence that would expose Mervyn's complete lack of remorse. Robert Carver delivered the defense opening with considerably less confidence. He painted Mervyn as a young man who had made a terrible mistake in a moment of fear. The fight had escalated quickly, Carver argued. Mervyn had felt threatened. He had pulled a knife to defend himself. The death of Anthony Reyes was a tragedy, but it was manslaughter at worst, not murder. Mervyn sat at the defense table with his arms crossed, occasionally glancing at the jury with what might have been intended as a remorseful expression, but came across as bored indifference. When Carver mentioned Anthony's name, Mervyn did not react. He simply stared at the ceiling, as if waiting for the speech to be over. Judge Warner watched this performance with growing irritation. She had seen defendants try to appear sympathetic before, but Mervyn was not even trying. He was openly contemptuous of the proceedings. The prosecution's first witness was Carla Diaz, the bartender. She took the stand and was sworn in, her hands trembling slightly. Brennan asked her to describe the events of that December night. Mervyn and Anthony were both at the bar, Carla said. They came in separately, but ended up talking. At first, it seemed friendly, but then their voices got louder. I could not hear everything, but I heard Mervyn say something like, "You always think you're better than me." What happened next? Anthony tried to leave. He put money on the bar and headed for the door. Mervyn followed him. Before Mervyn left, I heard him talking to another guy at the bar. He said, "He's done embarrassing me tonight. I'm going to shut him up for good." Did you take that as a threat? Carla nodded. Yes, it sounded like a threat. But I did not think he would actually do anything. I wish I had called someone. On cross-examination, Carver tried to suggest that Carla had misheard, that the statement could have been hyperbole, the kind of thing people say when they are angry but do not mean literally. But Carla was firm. I heard what I heard. And 20 minutes later, Anthony was dead. The next witness was one of the paramedics who had responded to the scene. His name was Daniel Ortiz, a man in his early 30s who had been working emergency services for 7 years. He described arriving in the alley to find Anthony Reyes lying on the pavement, multiple stab wounds, massive blood loss. And standing a few feet away was Mervyn. What was the defendant doing when you arrived? Ortiz's expression darkened. He was standing there, looking down at the victim, and he was laughing. The courtroom went silent. Several jurors looked at Mervyn with visible shock. Mervyn, for his part, simply shrugged and muttered something to Carver. Can you describe the nature of his laughter? Brennan asked. It was not nervous laughter, Ortiz said. It was, I do not know how to describe it. It was like he found something funny, like he was entertained. Carver objected, arguing that Ortiz was characterizing rather than reporting facts. Judge Warner sustained the objection, but the damage was done. The jury had heard it. The medical testimony came next. Dr. Sarah Lynn, the medical examiner, took the stand and walked the jury through the autopsy findings. She used diagrams and photographs to illustrate the nature of Anthony's injuries. 7 stab wounds, she explained. 3 to the chest, 2 to the abdomen, 2 to the back. The wounds to the back are particularly significant because they indicate the victim was likely trying to flee when he was struck. Dr. Lynn, in your professional opinion, do these injuries suggest self-defense? Dr. Lynn shook her head. No, the pattern and number of wounds suggest a sustained attack. Additionally, there are no defensive wounds on the victim's hands or arms, which would typically be present if he had been fighting back. The photographs were difficult to look at. Several jurors turned away. Anthony's mother, sitting in the front row of the gallery, began to cry softly. Mervyn, however, leaned back in his chair and yawned theatrically. Judge Warner's voice cut through the courtroom like a whip. Mr. Huerta, you will sit up and show respect for these proceedings. Mervyn straightened slightly, but the smirk remained on his face. He glanced at the cameras and mouthed something that looked like, "You'll quote me." The prosecution built its case methodically over the following days. They presented the security footage showing Mervyn following Anthony through the streets. They presented cell phone records showing that Mervyn had sent text messages to friends in the days before the killing, messages that suggested premeditation. One text, sent 2 days before Anthony's death, read, "Watch me end it. He'll shut up forever." Another text, sent the morning of the killing, was even more damning. "Tonight's the night. Been thinking about this long enough." Brennan introduced these texts as exhibits, reading them aloud for the jury. With each message, Mervyn's story of a spontaneous fight in self-defense became less and less believable. Detective Sharif took the stand and described the investigation in detail. He walked the jury through the evidence collection process, the interviews with witnesses, the forensic analysis of the knife. He described finding Mervyn at his apartment, the blood on his hands and clothes, the knife hidden in the kitchen drawer. "Detective Sharif, did the defendant make any statements during his arrest?" Sharif nodded. "When we arrived, he was asleep. We woke him and informed him he was under arrest for the murder of Anthony Reyes. His response was, 'Took you long enough.' Did he show any emotion? Any concern?" "No. He was calm, almost relaxed. He asked if we could wait while he finished his coffee." The testimony painted a picture of a defendant who was not traumatized by what had happened, not shocked or remorseful, but eerily detached and self-satisfied. Throughout all of this, Mervyn maintained his performance of bored indifference. He would whisper jokes to Carver, loud enough for nearby jurors to hear. He would stretch and yawn during witness testimony. He would smile at reporters during breaks. And when Anthony's name was mentioned, Mervyn would sometimes chuckle softly, as if remembering a private joke. During one recess, Carver pulled Mervyn aside in the consultation room. His expression was furious. "Mervyn, you need to stop. The jury is watching you. They see you laughing, see you smirking. You are destroying any chance we have." Mervyn shrugged. "I'm just being myself, man. They can't convict me for having a personality." Carver leaned forward, his voice low and urgent. "They can and they will. You are making it easy for them. You need to show remorse. You need to act like you care that a man is dead." Mervyn's smile faded for just a moment, replaced by something cold and hard. Why should I care? He was an asshole. He got what he deserved. Carver sat back, stunned. For a long moment, he said nothing. Then he spoke quietly. "If that is how you really feel, then there is nothing I can do to help you." The trial moved into its second week. The prosecution continued to build its case. They called witnesses who testified about Mervyn's relationship with Anthony, describing years of resentment and jealousy. They presented school records showing that Anthony had received a scholarship that Mervyn had also applied for. They presented social media posts where Mervyn had made veiled threats. Then came a critical piece of evidence. GPS data from Mervyn's phone showed that he had purchased the murder weapon, the folding knife, 3 days before the killing. The purchase had been made at a sporting goods store 20 miles outside Ironvale. The store clerk testified that Mervyn had asked specifically for a knife with a locking blade, something sturdy that would not fold closed during use. Brennan asked, "Did the defendant explain what he planned to use the knife for?" The clerk shook his head. "No. I asked if he was going camping or fishing, and he just smiled and said it was for personal protection." The timeline was damning. Mervyn had purchased the weapon days in advance. He had sent texts describing his plans. He had followed Anthony from the bar, and then he had attacked him with a weapon he had specifically purchased for that purpose. This was not self-defense. This was premeditated murder. But the most devastating evidence was yet to come. Detective Sharif had mentioned during his testimony that there was additional video evidence that would be presented later in the trial. He had been deliberately vague, but the implication was clear. There was something the prosecution had been holding back. On the 8th day of trial, Brennan announced that the state had one final piece of evidence to present. She called Lieutenant James Corrigan, the supervisor of the county jail where Mervyn had been held during the trial. Lieutenant Corrigan, can you describe the security measures in place at the county jail? Corrigan was a large man in his 50s with a military bearing. We have comprehensive video surveillance throughout the facility. Every common area, every hallway, every holding cell is monitored 24 hours a day. The footage is stored on secure servers with strict chain of custody protocols. Are inmates aware that they are being recorded? Yes. There are signs posted throughout the facility informing inmates that they are under surveillance. Brennan approached the witness stand. Lieutenant Corrigan, approximately 3 days ago, were you reviewing surveillance footage from the holding area adjacent to this courtroom? Yes. As part of standard security procedures, we review footage regularly. And did you observe anything unusual on the footage from March 18th? Corrigan's expression hardened. Yes. I observed the defendant, Mervyn Huerta, in conversation with other inmates in the holding cell. He paused, searching for words. He was reenacting something, making stabbing motions with his hand, laughing. The courtroom went completely still. Mervyn, who had been slouching in his chair, sat up slightly, his smirk faltering for the first time. Brennan continued. Did the defendant make any verbal statements during this reenactment? Yes, the audio quality is clear. He was describing the attack on Anthony Reyes. He was bragging about it. And he made a statement about his planned testimony. He said, "Wait till I tell that mother how sorry I am." The gallery erupted in shocked murmurs. Judge Warner gavelled for order. Anthony's mother gasped audibly, her hand over her mouth. Carver objected strenuously. Your Honor, this is outrageous. The state is attempting to introduce evidence that was obtained, he struggled for an argument, that was obtained without proper notice to the defense. Judge Warner looked at Brennan. Counselor, when did you become aware of this footage? 3 days ago, Your Honor. We provided a copy to the defense immediately upon discovery, in full compliance with our disclosure obligations. Carver could say nothing. He had received the footage, he had watched it, and he had known in that moment that his case was over. Judge Warner ruled. The evidence is admissible. The jury will see it. Brennan had the courtroom's video system prepared. A large screen was positioned where the jury could view it clearly. The lights were dimmed slightly, and then the video began to play. The footage was in black and white, slightly grainy but perfectly clear. It showed the holding cell, a small room with benches along the walls. Several inmates in orange jumpsuits sat or stood around, and in the center was Mervyn. Mervyn was talking, gesturing wildly, clearly the center of attention. The audio came through the speakers, his voice unmistakable. So I'm like, you want to embarrass me? Mervyn was saying, his voice animated. Nah, man, not tonight. So I follow him out, right? And he's all, Mervyn, what are you doing? Leave me alone. And I'm like, Mervyn mimicked a whining voice, then laughed. Boom! He makes a stabbing motion with his hand, right in the chest. And the look on his face, man, like he could not believe it was happening. The other inmates were laughing. Mervyn continued, emboldened. Then he tries to run, so boom, boom. Mervyn made 2 more stabbing motions. He's crying, he's begging, and I'm just, Mervyn laughed again, a cold, cruel sound. I'm just watching him bleed out. Best night of my life. One of the inmates asked something inaudible. Mervyn's response was clear. Trial? Man, that's a joke. I got this whole speech ready. He put on a mock-serious expression and raised his voice in an exaggerated tone of false sincerity. I'm so sorry, Mrs. Reyes. I never meant for this to happen. It was an accident. I'm just a kid who made a mistake. He dropped the act and grinned. Wait till I tell that mother how sorry I am. She'll eat it up. They all will. The video ended. The silence in the courtroom was absolute. Mervyn sat frozen at the defense table, his face drained of color. The smirk was gone, replaced by something approaching panic. His eyes darted around the room, looking for an escape that did not exist. The jury stared at him with expressions of pure revulsion. Several jurors had tears in their eyes. One older woman was shaking her head slowly, her hands clasped tightly in front of her. Anthony's mother had collapsed against her husband, sobbing uncontrollably. The sound of her grief filled the courtroom. Brennan remained standing. Your Honor, the state rests. Carver did not even attempt a defense. He stood slowly. The defense rests as well, Your Honor. There was no point. The video had destroyed everything. Closing arguments were brief. Brennan reminded the jury of what they had seen and heard. The premeditation shown in the text messages. The purchase of the weapon days in advance. The sustained nature of the attack. And finally, the jail footage showing Mervyn's complete lack of remorse, his mockery of the victim, his plan to lie to the victim's family. This is who Mervyn Huerta is, Brennan said. Not the remorseful teenager his attorney wants you to see, but the cruel, sadistic young man who bragged about committing murder and laughed about deceiving a grieving mother. Carver did his best. He argued that the jail footage showed Mervyn trying to fit in with other inmates, that it was bravado rather than truth. But even he seemed to know it was hopeless. The jury deliberated for less than 4 hours. When they returned, the forewoman stood and read the verdict. Guilty of murder in the first degree. Mervyn sat motionless as the verdict was read. For once, he was not smiling. Judge Warner scheduled the sentencing hearing for the following week, but she made an unusual statement before dismissing the court. Given the nature of this case and the defendant's behavior throughout these proceedings, I am considering factors beyond the standard sentencing guidelines. Both parties should be prepared to address aggravating circumstances. The sentencing hearing arrived. The courtroom was once again packed. Mervyn entered in his orange jumpsuit, his swagger gone, replaced by a tense wariness. He took his seat and kept his eyes forward. Judge Warner allowed victim impact statements. Anthony's father spoke first, describing his son's kindness, his dreams of becoming a teacher, his love of music. He spoke of the hole Anthony's death had left in their family, a void that could never be filled. Then Anthony's mother, Rosa Reyes, approached the podium. She was a small woman in her 50s, her face lined with grief. She spoke slowly, her voice trembling. My son was everything to me. He was kind and gentle. He helped everyone he met. She paused, composing herself. And Mervyn Huerta killed him for no reason. Killed him and laughed about it, bragged about it, planned to lie to me about being sorry. Her voice broke. I heard that video. I heard him mock my grief before I even had the chance to express it. I heard him plan to manipulate me. And I want him to know, she looked directly at Mervyn, that I will never forgive him. Never. As Rosa spoke, Mervyn did something that would seal his fate. He chuckled. It was quiet, barely audible, but in the silent courtroom, it carried. Several people heard it. The judge heard it. Judge Warner's face transformed. Her eyes blazed with fury. Mr. Huerta, did you just laugh during a victim impact statement? Mervyn shrugged, the smirk returning for just a moment. I mean, she's being a little dramatic. The courtroom exploded. Rosa Reyes screamed. Bailiffs moved toward Mervyn. Judge Warner's gavel came down like thunder. Order! Judge Warner's voice cut through the chaos. Everyone will be seated and silent, or I will clear this courtroom. When order was finally restored, Judge Warner addressed Mervyn directly. She removed her glasses and set them on the bench, her hands visibly shaking with rage. Mr. Huerta, this court has tolerated your arrogance for weeks. We have watched you smirk and laugh and treat these proceedings as entertainment. We have watched you show absolute contempt for the victim, for his family, for this process. But your behavior just now, laughing at a grieving mother as she describes the loss of her son, that crosses a line I will not tolerate. Mervyn opened his mouth to speak, but Judge Warner cut him off. You will not speak. You will sit there and you will listen. She stood, leaning forward on the bench, her voice rising. You are 18 years old, technically an adult, though your behavior suggests otherwise. You committed a calculated, premeditated murder. You purchased a weapon days in advance. You sent messages describing your plans. You followed your victim and you attacked him with vicious, sustained violence. You stabbed him 7 times. You watched him bleed to death. And then you laughed. Judge Warner's voice was shaking now, not with fear, but with moral outrage. During this trial, you have performed for the cameras. You have smirked at reporters. You have made jokes. You have shown absolutely no remorse. And then we saw the jail footage. We heard you brag about the murder. We heard you plan to deceive this family with false apologies. We heard you laugh about it. She picked up the sentencing document. The standard sentencing guidelines for first-degree murder in Colorado allow for a sentence of life imprisonment with the possibility of parole after serving a minimum term. In most cases, that minimum is 20 to 30 years. She set down the document and looked directly at Mervyn. But this is not most cases. You laughed at a mother's grief moments ago. You have shown this court that you are not merely unremorseful. You are sadistic. You enjoy the pain you have caused. And that enjoyment, that cruelty, demands consequences beyond the standard. Judge Warner's voice dropped to a cold, measured tone. Under Colorado law, I have discretion to impose aggravated sentencing when a defendant's conduct during trial demonstrates exceptional depravity or contempt for the judicial process. Mr. Huerta, you have demonstrated both. Mervyn's face went pale. Whispers spread through the gallery. This court sentences you to life imprisonment without the possibility of parole for a minimum of 85 years. That is the base sentence for your crime. 35 years plus an additional 50 years imposed as an aggravating enhancement based on your conduct during these proceedings. The number hit Mervyn like a physical blow. His mouth fell open. 50? He whispered. You can't. That's not... His voice trailed off. Judge Warner was relentless. You laughed during evidence. You mocked the victim's family. You smirked at cameras. You bragged about the murder. You planned to deceive a grieving mother with false remorse. And moments ago, you laughed at her pain. Those actions demonstrate a level of cruelty that warrants the maximum penalty this court can impose. She leaned forward one final time. Your laughter lasted seconds, Mr. Huerta. These years will not. You will measure your life now in decades of confinement. You will grow old in prison. And perhaps, in that silence, you will finally develop the capacity for remorse that you so clearly lack today. Judge Warner brought down the gavel. This court is adjourned. Mervyn was led away by bailiffs. His swagger was gone. He walked like someone in shock, his face blank, his eyes unfocused. As he reached the side door, he looked back once at the courtroom. The cameras captured that moment, the exact second the arrogance drained away and was replaced by the dawning horror of what 85 years actually meant. In the gallery, Rosa Reyes sat with her husband, both of them crying. But there was something else in Rosa's expression now. Not satisfaction exactly, but a sense that justice had been done. Her son's killer would spend the rest of his life paying for what he had done. The case became a national story within hours. News outlets ran features on Judge Warner's unprecedented sentencing enhancement, on the legal questions surrounding punishment for courtroom conduct, on the broader issue of juvenile defendants who showed no remorse. Legal scholars debated whether the judge had overstepped her authority or had appropriately exercised judicial discretion. Some argued that 50 additional years for courtroom behavior was excessive, that it violated principles of proportional punishment. Others argued that Mervyn's conduct had demonstrated such exceptional cruelty that enhanced sentencing was not only appropriate but necessary. The case sparked legislative discussions in Colorado and several other states about formalizing sentencing enhancements for egregious courtroom conduct. A bill was introduced in the Colorado legislature, nicknamed the Huerta Amendment, that would codify judges' authority to impose additional sentences when defendants showed exceptional contempt or cruelty during trial proceedings. In Iron Vale County, the community slowly began to heal. Anthony's family established a scholarship fund in his name, supporting students who wanted to pursue teaching careers. The response was overwhelming, with donations pouring in from across the state. Mervyn was transferred to a maximum security prison in southern Colorado. He was placed in general population, and the other inmates quickly learned about his case. The jail footage had been widely circulated online, and Mervyn's bragging about the murder had made him infamous. Life in prison would not be easy. In his cell, Mervyn had plenty of time to think. 85 years. He would be 103 years old before he was eligible for parole. The realization settled over him slowly, crushing. He had thought he was untouchable, thought his arrogance and charm would carry him through. But he had miscalculated. He had underestimated the consequences of his performance. Detective Sharif kept a photograph of Anthony Reyes on his desk, a reminder of why the work mattered. The case had affected him deeply. The senseless nature of the killing, the defendant's complete lack of humanity, the family's profound grief. Lisa Brennan moved on to other cases. But the Huerta trial remained one of her most significant. She had proven that evidence could overcome even the most arrogant defendant, that truth could prevail despite manipulation and performance. And Judge Warner, in her chambers after the sentencing, sat alone for a long time. She had never imposed such a harsh enhancement before, had never added 50 years to a sentence based on courtroom conduct. But Mervyn's laughter during Rosa's victim impact statement had been the final straw. That moment had revealed not just a lack of remorse, but an active enjoyment of another person's suffering. She thought about the legal challenges that would inevitably come, the appeals that would question her authority to impose such a sentence. But she had no regrets. Mervyn Huerta had shown the court exactly who he was, and she had responded with the only language he seemed to understand: consequences. The surveillance footage from the county jail remained in the evidence files, preserved forever. It had been viewed millions of times online, becoming a cautionary tale about arrogance and the permanence of digital evidence. Mervyn had performed for what he thought was a private audience of fellow inmates, not realizing he was creating the evidence that would destroy him. The final image that haunted everyone who had witnessed the trial was not of Mervyn being led away in handcuffs. It was a still frame from the jail footage, frozen at the moment of Mervyn's widest grin as he bragged about the murder. That image had been shared across social media, printed in newspapers, broadcast on television. It was the face of sadistic arrogance, preserved forever as a reminder of what happens when cruelty meets consequence. Mervyn Huerta had wanted to be famous. He had performed for the cameras, had sought attention and notoriety, and he had gotten exactly what he wanted. He was famous now, but not in the way he had imagined. He was famous as the defendant who laughed his way into 85 years, whose arrogance had added 50 years to his sentence, whose performance had ended with silence and steel bars and the slow, crushing weight of a lifetime in prison. In the end, it was not the evidence of the murder that defined Mervyn Huerta. It was his own laughter. That chuckle during Rosa Reyes's victim impact statement. That moment when he could not contain his contempt, his cruelty, his absolute lack of humanity. That laugh had cost him 50 years. And in the cold mathematics of justice, it was a fitting equation. Seconds of laughter traded for decades of silence. Performance traded for permanent consequence. Arrogance traded for the rest of his life.